Governance expert, Professor Theo Venter, joins us now for more on the story. Prof, thank you so much for your time and for joining us this evening. So, Advocate Masuku, which is former President Jacob Zuma's lawyer, says that the state is the perpetrator of this unconstitutional conduct. What do you make of that statement?
Yeah, it's an interesting argument where the advocate is turning the tables around, saying that the state gave the money or presented or provided the money in an unlawful way, which of course is something that through this case developed. The fundamental principle here is that if you do something in the execution of your work as an official of state, whether it's president or minister or whatever, the state has got an obligation to protect you and to provide you with the resources to do battle in court. But if what you are doing is towards a private venture or towards corruption or anything that does not follow your official work, then I think through the different court processes over the last 15 to 20 years, it became very clear that the state cannot provide support if you've done wrong things while serving in whatever position. And this is also going to be applied, I think, once the Madlanga Commission has finished their work, and in some cases the Zondo Commission, where state officials are involved. I think the state will very carefully look at when to support and when not to support. So, yes, I think in the beginning, President Zuma got support for basically all his cases until people realized we're doing the wrong thing here, and the advocate is using that now in his arguments.
And how do you think, or how effective are just the current accountability mechanisms in holding former and current public officials accountable for misuse or misallocation of state resources? Does this case exemplify strengths or weaknesses in the system?
I think if we take President Zuma out of the equation, because his case is in a sense special, because it has such a long duration, and I think the courts and the legal profession has learned a lot through how a Stalingrad defense is working and how you can actually prolong a case over time, that people almost forget about what happened in 2010 or 2015 or whenever. I think the state is now much more aware of what to do earlier on and those kind of things. But I think in this specific case that you mentioned, I don't think it's possible to get almost 29 million from President Zuma. I think this court case with the government or the presidency and the DA as a support is kind of putting pressure on Mr. Zuma to stop his strategy, because his strategy is going to become more expensive over time, and we need some finality in this case. And I think Mr. Zuma's whole strategy is, if you can prolong these cases through technical measures, and he has become a master of technicalities in courts and his lawyers, of course, over time is going to become the biggest enemy of what's happening here. And I think the judge has got a huge problem sorting this out, because taking away Mr. Zuma's pension is going to have an effect into his whole extended family. And I think that is something that we heard in this case. But I think the purpose is not to get all the money. The purpose is to put pressure on President Zuma and his team to sort out their cases so that we can get finality.
I mean, you speak about that possibility of tapping into his pension funds. What precedents do you think that would set? Well, there's several examples of civil servants, in any case, caught in the act or accused of corruption and were found guilty, where the pension fund is the first thing that
the SIU or some of these institutions would lay claim on. So it's not, we've got several examples of that. But in the case of Mr. Zuma, he receives a pension equal to his salary as president, and with a few additions to it. But it is very, very far from 28 or 29 million rand. So I think that is the biggest challenge the court is having with that case. Personally, I think they're going to make a kind of a compromise decision here that he starts paying something, and because currently I think he's not paying a single cent back of the money that they've used so far on his cases, providing state support.
So beyond legal recourse, Prof, what preventative governance measures do you think need to be implemented to avoid the misuse of public funds by officials or even former officials in this way?
Let's go back to the cases that also caught our attention this week, whether it's the Madlanga Commission or the ad hoc committee. One of the issues that is at play here is where does the power or the authority of a minister ends, and where does the power or the authority of an official starts? There's a grey area there, and I think in the past those areas were not well managed, and I think that is the first thing we have to do. We have to find out what officials can do and what politicians can do. Now, what happened in South Africa over the last 30 years, and it is not new, it also happened in the previous dispensation. If you're in power for so long, like 20 years, 25 years, or 30 years, the people in the top positions and the politicians grow closer to each other. In other words, either I can't say that a DG is an ANC member, but at least he has sympathy with the ruling party, that kind of thing. So when a minister comes down on you saying, listen, this is maybe on the edge of what we can do, but I suggest you pay that. And then the official, since they're so close and since they share certain things, that he would do that. And this is exactly what I think happened between Masemola and Senzo Nchunu. Now, if we apply that to how the state acted in some cases, I think we need greater clarity about what is possible and what must happen and what can happen, and to distinguish the two from each other.
Prof, thank you so much for your time and for joining us this evening. It certainly has been valuable. That is Professor Theo Venter on governance and accountability.